And now I would like to introduce the next speaker, the next guest speaker of ours, who I have the biggest honor to introduce. It's Dr. Lee Andrew Bygrave. He's a professor at the Department of Private Law and University of Oslo, where he is director of the Norwegian Research Center for Computers and Law. And what I'm most happy about while presenting Mr. Lee Andrew Bygrave is that he's one of the co-authors and co-editors of the comprehensive article-by-article analysis and commentary on the EU GDPR, which I have at my hand, so it's like a commercial, but it's definitely not for commercial purposes. I just really want to tell that the speakers we have here today at the panel are really the ones making the biggest impact on GDPR and privacy data protection laws and those positive cultural shifts, as we just discussed with Valentinas. So, Mr. Lee Andrew Bygrave, I could continue introducing you with a lot of things I have on my table, on my paper, but I think this is something that introduces you the best. If not, please add something from your side as well. So the floor is yours.
Thank you very much, Migla. It's a pleasure to be sort of here in Vilnius. I'm speaking from snowy Oslo, and yeah, it's great to be able to communicate over a fairly great distance, despite these pandemic-challenged times. So I'm talking about data protection authorities, but which are definitely a modern phenomenon. But I'm going to return many, many years back to the days of ancient Greece, because back in those days, when people who sought answers to the mysteries of the world wanted answers, they would go to the oracle of Apollo at Delphi to get answers and guidance. And even the powerful of the time sought help from the oracle. And this particular image is an 18th century painting depicting Alexander the Great seeking counsel, supposedly back in 336 BC. Well, today in 2021, one of the great mysteries of the world is the GDPR. And for many people, the GDPR represents the huge, impenetrable bureaucratic structure that is so brilliantly depicted in Franz Kafka's novel, The Castle, or Das Schloss. And for me, the GDPR is Das Neues Schloss. And behind its walls, there lie semantic mazes, winding procedural alleys, subterranean cross passages, and an immense bureaucratic apparatus. And who do we approach for answers to its riddles and to its mysteries? We go primarily to data protection authorities, or supervisory authorities in the GDPR's terminology. They are our modern oracles of first resort in the data protection universe. And provision of guidance is officially part of their mandate, but that is just one of many tasks, because data protection authorities, or DPAs, are multitaskers par excellence. And if you look at Article 57 of the GDPR, you'll see that it enumerates over 20 tasks that DPAs must undertake, including the very generically formulated task of, quote, fulfilling any other tasks related to protection of personal data, end of quote. And to discharge their very broad mandate, they are also given numerous powers. And Article 58 of the GDPR sets out 26 powers, many of which are rather discretionary. So all up then, their extensive mandate and powers give data protection authorities considerable discretionary authority. But with this authority, there do come problems. First, some of their mandated tasks are in tension with each other. In particular, there's a tension between their advocacy-related tasks, such as promotion of data protection awareness, with those tasks that require a unbiased interpretation, application, and enforcement of the law. And how data protection authorities strike that balance between the advocacy and more sort of apolitical enforcement approach to their role, that is done quite differently. Some commentators claim that there is a growing East-West divide in this respect. More specifically, they claim that data protection authorities in Eastern Europe have gone over to being mere enforcers of law, adopting a technical rather than political approach to their work. Whereas, they would say, the European Data Protection Supervisor in Brussels is increasingly adopting a political advocacy-oriented approach. So that's one difficulty, internal tensions between tasks. Secondly, the scope of their discretionary power and the inevitable trade-offs that the exercise of that power entails in specific contexts point to larger dilemmas and contradictions that have plagued independent regulatory authorities more generally. And in particular, there is a basic tension between DPA's extensive powers and their lack of a direct democratic mandate. And that lack of a direct democratic mandate then creates problems for their legitimacy. DPAs have largely relied on their expertise to shore up their legitimacy. This is underpinned by their specialized and largely exclusive remit over an area of law that confers upon them a body of knowledge that is relatively mysterious to others. And the relatively minor, if not marginal, role played by national courts in interpreting the relevant data protection laws has then also bolstered data protection authorities' authoritative position as the primary disambiguators of data protection norms. This interpretative status and power, I guess, can bolster their authority, but it's a double-edged sword. Because if data protection authorities fail to offer clear and timely guidance that satisfies the needs of wider society, they will be vulnerable to criticism. And we saw this criticism surfacing in the recent official evaluation of the GDPR's application, where the Council in particular was quite critical of the slowness with which data protection authorities and the European Data Protection Board were acting in providing guidance to processors and controllers. But also we saw industry representatives voicing criticism through the so-called multi-stakeholder expert group, saying that not only was the European Data Protection Board failing to provide timely guidance, quite often the guidance it was providing was inconsistent. Now, these shortcomings are due not simply to the scale of the GDPR's textual ambiguities, but also to data protection authorities' lack of capacity. Many of them have suffered from long-term chronic shortages in staff and other resources. The Irish Data Protection Authority is often seen as particularly undernourished in this respect, given that it's got Facebook, Google, other digital Goliaths on its home turf. And there's a lot of expense, a lot of complication involved in auditing their operations and ensuring they comply with the law. The resource shortage compromises data protection authorities' ability to fulfill their wide-ranging mandate under the GDPR, including their responsiveness to demands for clear guidance. They are being asked simply to do too much. And there is an unrealistic assumption by legislators that DPAs can smoothly follow the line drawn in the law, but this is in reality akin to walking on water. And while the Oracle of Apollo might have been able to walk on water, data protection authorities cannot. There's yet another problem, and that is that even if data protection authorities do provide timely guidance, some people might regard the guidance as biased towards privacy and data protection. And there have been long-running perceptions on the part of many governments and businesses that data protection authorities are, in effect, flies in the ointment. In other words, actors that get in the way of legitimate needs for governments and businesses to achieve their respective goals efficiently. The US privacy scholar Julie Cohen said that privacy has long had an image problem in that it is regarded as, quote, anti-progressive, overly costly, inimical to the welfare of the body politic, end of quote. Well, the same goes for data protection authorities. But conversely, for the pro-privacy people, the privacy advocates like NOYB, none of your business, data protection authorities are somewhat paradoxically seen as a problem as well. They might not be flies in the ointment, but they are simply bottlenecks. And so these organizations are increasingly jumping over the data protection authorities and going straight to the courts to get real traction for data protection norms. And some would say that jumping over data protection authorities and going straight to the judiciary is undermining data protection authorities' status and authority in a fairly fundamental way. I would disagree because so far, the Court of Justice of the European Union, along with the European Court of Human Rights, so far, most of their case law has shored up the walls of data protection against the relentless pressure of business and government interests to process ever greater amounts of personal data for self-interested ends. And in shoring up the walls of data protection, ultimately, the courts have offered a lifeline of support to data protection authorities. In other words, the courts have been allies and not enemies of DPAs. And I think that's likely to continue. Thank you.
Thank you very much for your very interesting presentation. Some of the audience representatives have asked what is the book I have holding in my hand. So I have to show you once again. So it's EU General Data Protection Regulation, a commentary. So one of the authors, as I mentioned, is Mr. Andrew Bygrave, who has just presented his view on the data protection authorities. And it's,
I might just add, it's 1,600 pages, which is one of the biggest books that Oxford University Press has ever published.
Yes.
And it just underlines my point that, you know, the GDPR is a big beast and a very mysterious beast, and that is another beast. So unfortunately, one beast breeds another beast, but it is a type of oracle.
Yeah, so I have it, you know, a little bit crossed and written in a little bit, so I'm not going to show you the whole, but it's really, really big one. So any funny stories to share about how you wrote this beast?
Well, this was an initiative that Christopher Kuna and I discussed many, many years ago, back in 2012, just as the first proposal for the GDPR was being issued by the Commission. And there's been a lot of work involved, and I must say that this is a team effort. So I'm one of many co-authors. I'm one of 3 co-editors, but we've got about at least 20 people on board from all over Europe, both academia, bureaucracy, business, so a wide variety of perspectives. And the book has been quoted already many times by the Advocates General in the Court of Justice. So it's the leading authority on GDPR mysteries, at least in the English language. There are also a lot of German language commentaries, and there may be some from Lithuania. I don't know.
Yeah, we have a few, yeah, but not that expensive. So there was one question from the audience a little bit earlier, probably a couple of hours ago, but I believe that this is the right time to address it to you specifically, because it was given, just generally without specifically addressing it to any of the speakers. So one of the persons from the audience was asking that whether it was beneficial for a data subject to complain to a supervisory authority about a data breach. Would you believe? Would there be any additional value to that? Maybe it's better to consult with the service provider directly. Would you have any insights on this?
My limited experience would be to pursue both avenues. So you do both. You go both to the service provider and to the data protection authority concurrently. But it depends on the nature of the breach, and also what sort of history one has with that particular service provider. Is it a service provider that is always on the front foot to go out of its way to make sure that customer relations are on a good footing, or is it a cowboy in the business and unlikely to take action? So, and if that's the case, then it's better to probably go straight to the supervisory authority.
So thank you very much for your presentation. So not to be running out of time, I will invite the next speaker of ours. Thank you very much once again, Lee, for being here with us today.
Bye-bye.